welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Professor Patricia Cain. And Patricia is a professor of law at Santa Clara University. I'm just going to call her Pat. I think we're both more comfortable that way. She's been teaching law for many years. She started when she was 2 years old. She briefly practiced law before she became a professor. She's a member of the Texas and Iowa bars and provides consulting services to law firms. Pat is a frequent speaker related to tax planning for same-sex couples and has written many law review articles on the subject. Locally, we have a tax conference that we both go to as the Kasner Estate Planning Symposium, and so she gives an update related to her subject on this each year there. And so we're delighted to have her in our community. So today we're going to be talking about her specialization, which is federal tax developments for same-sex couples. I'd like you to know that today's date is January 6, 2015, because we do have a moving target in some ways, particularly as far as states recognizing same-sex couples. It's been sort of blossoming out.
A new one every day.
Yeah, seems that way.
Including today.
Yeah,
State of Florida.
All right, yeah. So anyway, yeah, very exciting for the same-sex community there. So anyway, as we get started, I just want to caution our viewers that we are discussing issues in a complex area. Anytime we're talking about the tax law, it's complex. So anyway, it's just a starting point for a bigger discussion that you should have with your attorney, your tax advisor. And also, we're mostly addressing issues from federal and California standpoints because we're both California residents, although Pat does speak around the country. But in particular, California is a community property state, and we have our own flavor of community property. It varies from state to state. And so viewers in other states should definitely seek advice about their own local laws. Pat, thanks for joining me today.
Thank you for inviting me.
Yeah, I just appreciate having you here. So I guess we'll just sort of start at ground zero. Back in, I guess it was about June of 2013,
right,
was this Windsor decision handed down by the Supreme Court, and it's changed the tax landscape for same-sex couples. So maybe you should lay a little groundwork for us here.
I mean, there are really two issues overall. It is,
okay,
are same-sex marriages recognized in states?
Mm-hmm.
But Windsor was about whether or not the federal government would recognize valid same-sex marriages from those states.
Right.
And it all, of course, started back in 1996 with the Defense of Marriage Act, DOMA,
mm-hmm.
Which said the federal government would not recognize any same-sex couple as married for purposes of federal law at all, including tax law.
Mm-hmm.
Lots of challenges in the court, and then finally in June of 2013, the United States Supreme Court, in a 5-4 decision, pronounced that the Defense of Marriage Act was unconstitutional. From thence on, of course, the federal government has been told, all agencies, that they
mm-hmm.
must recognize valid same-sex marriages. That was a huge, huge victory for
mm-hmm.
the same-sex couple community.
Yes. So did that case tell us anything about which marriages should be recognized?
Well, that case involved a couple that had been married in Canada,
right,
but were domiciled in New York, and New York recognized their Canadian marriage.
mm-hmm.
So it didn't tell us anything beyond the fact that that type of couple had to be recognized, i.e. somebody married and living in a recognition state.
Mm-hmm.
So there's a lot of speculation after the decision about what federal agencies how they would treat that. What if you're married in California but living in Texas, which is still a non-recognition state? Finally, the IRS answered that question for us, and they simply said, we will recognize you as married if you are validly married in any jurisdiction that recognizes same-sex marriages. In other words, a very broad rule and beyond the facts in the Windsor case.
Mm-hmm. But I guess an administratively practical.
Very practical. In fact, employers around the country were contacting the IRS and said, please, please, please don't tell us we can only recognize marriages if our employees are living in a recognition state. I mean, think about the D.C. area where at the time D.C. recognized marriages, Maryland then recognized marriages, but Virginia didn't. And easy enough to have Virginia does today, but it
Yeah.
did not then. And if you have employees from all of those states, you don't know what tax rules to apply to them unless you know where they're domiciled. And what if they move? They got to tell the employer, I've now moved to a non-recognition state. It would just be a pain for all of the employers to keep up with.
Yeah, and those eastern states are smaller, like
Much
you
smaller
said.
than
Yeah,
California.
yeah.
Yes.
So like Delaware and
Yep.
District of Columbia, Virginia. I mean, these are all hop, skip, and a jump from
Exactly.
each other. Where, you know, when we live in California, you have to drive 8 hours to get someplace. Not quite that extreme, but still, I mean.
Depending on where you live in
I mean, you
California.
drive a couple of hours and you're across Florida, right? So, I mean, I went there and I was amazed, you know, that the maps were a lot more compressed.
Mm-hmm.
Well, anyway, so federal agencies. Let's start with the IRS.
Yeah, the IRS
What have they
finally
done?
on August 29, 2013, issued its revenue ruling. And it's important that it's a revenue ruling because that's stronger authority than some of the informal statements that they had issued before that. And basically they said, well, three main things. The place of celebration rule, we will recognize all marriages that are valid in whatever jurisdiction they were entered into, so long as that jurisdiction recognized them as valid. And the decision applies retroactively at the taxpayer's election. So if it's beneficial to you to claim that you've been married in past years, you can claim it. If it's harmful to you, for example, high-income two-earner families that might pay the marriage tax penalty, then you can continue to maintain that all of your prior years were as single taxpayers. The IRS is not going to come in and audit you and say, now you have to file for 2011 as though you were married.
Yeah.
So that was beneficial to taxpayers. And then probably most important, and it's the only part of the ruling that I personally disagreed with, they ruled that registered domestic partners, California has registered domestic partners. California treats registered domestic partners exactly the same as spouses for purposes, especially for tax purposes, but the IRS is not going to recognize them as spouses.
Right. So basically it says if you're married, you got to be married.
You got to be married to be
because neither-
treated, yeah. And a lot of people were surprised at that because some years ago, the state of Illinois enacted a civil union statute, which is the same thing as a registered domestic partnership statute. And under their civil union statute, it applied equally to same-sex couples and opposite-sex couples. So someone from H&R Block wrote to the chief counsel, well, they wrote to the commissioner turned it over to chief counsel and said, if I am filing returns for opposite-sex civil union partners who are treated the same as husbands and wives under state law, how do I file? Do I file them as single or do I file them as married, filing jointly? And an informal letter, no authority, came back out of chief counsel's office and they said, well, if the state treats them as married, you must file a joint return for them.
Oh, that's interesting.
Now, so they've totally changed their mind,
Yeah,
obviously.
yeah.
I mean, it was, they've just decided no matter how like spouses you are, you have to actually enter into marriage.
Yeah. Well, there's some risk in relying on chief counsel advice anyway, I think. If
it's informal, yeah.
I've seen some pretty, stuff. Well, I've seen stuff that, let's just say that they've had changes in position or whatever.
Well, yes, they
later
changed
time.
their position earlier, you may remember, on registered domestic partners. In 2006, they issued something called a Chief Counsel Advisory, a CCA, which doesn't have authority, but said that even though registered domestic partners were subject to the same community property rules that spouses were, the community property tax rules did not apply to them.
Yeah.
This is an old famous case, Poe versus Seaborn from the U.S. Supreme Court in 1930, that said in the community, and in those days there was no joint return, so for husbands and wives who had community income, they were able to split their income 50-50.
Right.
Now I thought great when the community property rules were extended to registered domestic partners. If you've got a high income partner and a low income partner and they get to split their income, they're going to lower their tax bill. But 4 years later, in 2010, they changed their mind on that one and said, yes, you're absolutely right. Poe versus Seaborn and community property rules do apply to registered domestic partners. So even though you're not taxed as spouses under the IRS ruling, the IRS will recognize the state laws that apply to you, and if they affect your tax situation, they'll recognize it. So registered domestic partners will continue to split income. A number of questions have come up about what about the other tax rules? What happens when registered domestic partners divorce? They don't go through a formal divorce, but they go through a judicial dissolution that is exactly like divorce in many cases. Well, is alimony taxable to them? under the code, we have sections that say it is sometimes and it isn't other times, but those provisions only apply to spouses. They can't apply to
Right.
registered domestic partners. I argue that the alimony is not taxable because of a 1917 U.S. Supreme Court case, Gould v. Gould, that said alimony, because it was, required by the state, et cetera, would not be taxable to the recipient. And the same problem with splitting up of property, right? We've got a special rule in the tax code that it's not a taxable event when you split property at divorce, but it uses the word spouse in the statute,
Right.
so it can't apply to registered domestic partners, although it should. There's case law, there's arguments that it's still a non-realization event so long as you're splitting up community property fairly equally. The real problem for registered domestic partners is trying to split retirement plans, because the only way to do that correctly, that is to give the non-earning spouse, the non-employee spouse, 50% of what they're entitled to under community property rules, is to get something called a quadro, a qualified domestic relation order. Again, only applies to spouses. And so, oddly enough, some lawyers are saying, oh, you want to dissolve your registered domestic partnership and you want to be sure what the tax rules are? Get married first.
Yeah.
Get married in contemplation of divorce.
Isn't that funny?
I think that's my argument to the IRS.
Yeah.
Why are you are forcing these people to do that by not applying the correct rules to this couple?
Yeah. And then I guess the question would be, if you had an agent, then would argue, well, this marriage should be disregarded because you did it in contemplation of divorce.
Sure, there is of course that possibility. It's a sham marriage, right?
Yeah.
Because it wasn't, it's like an immigration sham marriage. You're just doing it to get the benefit of the tax rules.
Yeah.
But well,
It's wild. But I mean, on the other hand, from an equity standpoint, they would be better off just sort of looking the other way because they're
Right.
they're opening a can of worms.
that's what I think.
I mean, we had the same can of worms even that we used to deal with divorces years ago.
Exactly.
Before they liberalized
they
the rules.
got the
We
rules.
basically, you could have a taxable exchange of your property.
Right.
And
Divorce
so,
used to be a taxable event
Yeah.
for married couples. In
Yeah.
fact, the case that decided that was in 1962. It took them all the time up until 1984 to correct that rule in the statute.
Yeah. Time flies, doesn't it? 30 years ago. It doesn't seem so long ago, but anyway, but I remember that, I mean, of course, I've been in public accounting for about 10 years, so I had gone through this thing of, studying what you do related to a divorce, and
Right.
and that it was a very complicated problem, especially when people had even separate property that they were selling,
Yes.
whatever, and oh my gosh. So these issues still exist for registered domestic property partners. Yeah, sorry. Why don't we talk for a few minutes about other federal agencies and how they're handling this business of now,
Right.
really, I guess, converting over. Now we've got a year, almost 2 years under our
Right.
belt, or a year and a half.
Yeah, all agencies have spoken now. The first agency to speak was OPM, the Office of Personnel Management, speaking about federal employees and to get benefits for their spouses. And they clearly adopted the rule that I assume the Department of Justice, who was overseeing this, wanted all agencies to adopt, and that was, we will recognize marriages that were valid in the state or location where they were performed. So again, the place of celebration rule. Domicile is irrelevant. And every agency that, before the IRS spoke, also said that registered domestic partners and civil union partners would not be recognized. There were a couple of problems. There's still one problem. Social Security has a statute. There's no definition of spouse in the Internal Revenue Code, except for the definition that says if you're married on the last day of the taxable year, you're married the full year. But marriage is defined by the state, so you have to decide in a conflict of law situation which state law you're going to apply. And basically, where possible, the agencies have all agreed that it should be place of celebration rule. The problem under Social Security is there's a statute. There's a statute that says when you apply for benefits, which can be at retirement, or if the spouse that was covered by Social Security has died, it would be after the death of that spouse. If you've applied for benefits, you will get spousal benefits so long as you are domiciled in a state that recognizes your marriage. So that's a problem. If you can plan, you can move to a state that recognizes when you retire, and if you apply and get the benefits, you can then move back, because moving from a recognition state to a non-recognition state doesn't affect it. But you can't do anything if your spouse has already died. And so Lambda Legal Defense has brought suit in the District of Columbia, in the federal court there, challenging this rule. They're suing the Social Security Administration and saying you are violating principles of equality under the Constitution, exact same argument as in Windsor, because you're not honoring these marriages, and you should. And they're suing on behalf of a widow of a Texas resident.
I see. So I'm just curious, has there been any proposed legislation related to this, or?
Sure, but it's not going to pass this Congress.
Yeah, the problem is...
There have been proposed amendments both in the House and the Senate by people who want to help out here and amend this, but...
The problem is getting anything through Congress. That's and that
now,
the President will sign.
Yeah.
Oh, dear.
Yeah, and there are a couple of other problems that were there. For example, veterans benefits. There's a statute there as well. But here's how the Veterans Administration has decided to construe the statute. It says place of residence, first of all. It doesn't say place of domicile. So it says, and it talks about you have to be in that place at the time the claim arises. And Veterans Administration says the claim doesn't arise until you've met all of the conditions. So if you're applying for veterans benefits and you currently live in a non-recognition state, the minute you move to a recognition state, you're entitled to those benefits. It's kind of a liberal construction, but that just shows you how much the federal government is really trying to do what's equitable and try to make up, I'd say, for the past years of really looking down on same-sex couples as second-class citizens.
Yeah, challenging. Okay, well, let's talk a little bit about, we were talking about the situation a few minutes ago, about should you amend back your returns. And one thing that we're going to see now in California, since we were recognizing, have been recognizing same-sex marriage for a little while now, part of what's going to happen is that this is going to move into the past. We're going to have a statute of limitations for going back and amending. But maybe you could just talk about that issue for a few minutes.
A 3-year statute of limitations. If you filed before April 15th, the 3-year statute is triggered as of April 15th, and you have to file an amended return within 3 years from that date. If you filed on extension sometime before October 15th, there's a 3-year statute that runs from the date that you filed, not from the October 15 date. A lot of people weren't clear about that. So for any year that's still open, and if it's beneficial to you, yes, you should file an amended return. I don't think many same-sex couples are registered partners, well, they can't amend anyway. Same-sex spouses in California should amend because they've been splitting their income 50-50 under the community property rules.
Well, let's say they should have been, yes.
Well, they should have been, yeah. And if they did, then
it's not going to change much.
It's not going to change much. Now, I do know of one situation where a couple miscalculated, thought they were entitled to a refund, and for our tax year that was about to close last April 15. And so on April 15th of 2014, they filed an amended return claiming this $2,000 refund. But they had miscalculated their prior refund, and the IRS came back to them and said, actually, now that you filed as married, you owe us an additional $5,000.
Oh.
And when the person who worked on the return called me, I said, well, that's not a problem. The statute of limitations is run, because the statute of limitations, if you amend on April 15 and show that you owe tax, there's an extended 60-day limitation period under Section 6511 of the Internal Revenue Code. The IRS took the position that that was not the right statute of limitations. There's a different statute of limitations under Section 6013, which deals with husbands and wives and joint filing. And it said, in that, if you used to file separate, meaning married filing separate, not single. If you used to file separate and now you file as married, there's a 1-year statute of limitations from the time you file. The revenue ruling clearly says it's the 3-year Section 6511 statute that applies. It does not apply Section 6013. So I think the agent is just wrong, and this will be sorted out at some point.
So remember, folks, how I talked about how this was a complex area.
Yeah.
So, was there anything else that you wanted to add in the area of retirement plans?
Well, retirement plans are important. There are a number of issues there. I mean, this is partly the IRS and it's partly Department of Labor. And retirement plans, at least ERISA-covered retirement plans, have certain rules in them to protect spouses. You must name your spouse as your beneficiary at death of an ERISA-covered plan. And of course, because of DOMA, that rule didn't apply to same-sex married couples until June 26, 2013. So do plan administrators now have to go back and amend the definition of spouse? A lot of plan administrators just took the DOMA language and put it in their plan and said the only people protected here are opposite-sex spouses. So the IRS has made announcements on this and said you must amend your plan to at least change that as of June 26, 2013. It's complicated to go back and amend the plan retroactively, like for years before, so that we're not going to require you to do that. The IRS is not going to require the administrator to amend it. And so if they were only giving protection to opposite-sex spouses before June of 2013, those spouses might be out of luck. And what I'm talking about here is assume someone died June 1, 2013, before Windsor came down.
Yes.
And she was married to a same-sex spouse, but she had named her mother as the beneficiary. The surviving spouse says, wait a minute, I'm now recognized. It's now July. I am now recognized. I want the death benefits, and the mother should not get them. We had a case. We had a case just like that came down last July after Windsor. It was the Tobitz case, and the parents had actually pressured their daughter basically on her deathbed. It was a very sad story, into signing, making them be the death beneficiaries.
Yes.
The employer plan wanted to do the right thing, so they simply put the money in the court's hand and said, court, you decide. Is it the mother or is it the same-sex spouse? And the court said, it's the same-sex spouse. That seems right to me. However, if the plan administrator has already paid out hundreds of thousands of dollars to the mother, they're going to be a little reluctant to pay out to the surviving spouse. That's not something the IRS has any control over. There are cases out there, and they will be litigated if they're not settled beforehand, where some surviving same-sex spouses are asking for those funds. And they've got some support. The Office of Personnel Management said for federal employees, their federal employees are covered by different types of plans, but they've got some of the same spousal protections in that if you are survived by a spouse, the spouse typically on some of these plans gets a lifetime annuity. Those were not being done for any deaths before the Windsor decision, but OPM says apply now. If you have a spouse that died before Windsor, you are entitled to these benefits, apply now. So, and I think that's the right rule.
So, but yeah, it's hard to take back the money. I mean, it's gone, it's spent.
You just, I mean, right.
So
you're just
it's
lost.
going to have to be like a prospective, we can correct the situation for what happens in the future, but we can't.
Well, they can. They just out the money.
Yeah.
Well, under the federal employee plans, if the mother gets something, it's probably a small lump sum as opposed to a lifetime annuity, because the spousal benefit would always be much greater than another beneficiary.
I see what you're saying.
So
okay.
it depends on the plan.
Yeah. Okay. So what you're saying is that they may have treated something as a settled benefit before, but when you look at what a spouse is entitled to, it's not settled.
Right.
And so you can go back and say, well, wait a minute, we need to re-examine this issue. That's really an important thing to take away from this interview. We only have probably about 2 or 3 minutes left, so maybe you can talk a little bit, though, about employer plans.
Well, there's another issue about these employer plans that people seem to misunderstand, and that's about the health benefits.
Yeah, that's a big deal right now.
Some employers give health benefits, and some employers give health benefits to spouses. And some employers give health benefits only to opposite-sex spouses, still. Still.
Uh-oh.
Yeah, and so people think, well, wait, the Department of Labor has said that you have to treat these people as married. But truth is, there is no requirement under federal law that any spousal benefits be paid. So the employer is perfectly free to not give any spouses, to give blue-eyed spouses only, same-sex spouses only, or opposite-sex spouses only. The only way to knock out that kind of discrimination is to demonstrate that it is violating a federal law. It doesn't matter if you have state laws that do protections. They're all preempted under ERISA plans. So you have to have a federal law. And we have no non-discrimination policy at the federal level. It has never passed the Congress. But we do have Title VII that bans discrimination on the basis of sex. And so the argument is, if you will give it to my male spouse but not to my female spouse, that is sex discrimination. And in fact, again, there's a case that's in the state of Washington, just came down about a month ago, making this argument. And the employer said, that's not sex discrimination. And the court said, well, it might be. We're going to send this to trial and see. The case is Hall versus BNSF Railway, and I'm keeping an eye on that.
Okay, so we'll stand by on that. So maybe we just have maybe a minute left for you. Maybe you can throw out a final thought or two. And
well, I think the thing to take, really look at is the spread of same-sex marriage, as you were speaking at the beginning of the program. We now have 36, maybe even 37, because people are getting married in Missouri as well, although it hasn't been officially counted on anyone's map as a recognition state. And the Sixth Circuit decided in 4 cases, decided at the same time, that the Constitution was not violated by non-recognition of same-sex marriage. So those 4 cases and a case from Louisiana are pending right now before the United States Supreme Court. And they haven't said they'll take it yet. They're just discussing it this very week. But pretty soon we're going to know whether they'll take one, more, or all of those cases. And if they do, and they do it fairly soon, we could have a decision by this June that says same-sex marriage must be recognized throughout the United States. And that'll be great going forward. It's not going to solve some of these problems of the widow who died and didn't get her benefits and that sort of thing. There'll probably still be litigation. But I predict we'll get a 5-4 or maybe even a 6-3 decision in favor of same-sex marriage this June.
Well, that will be something. I mean, again, looking back over our 40 years or whatever in this profession and in the law profession and CPA profession. It's amazing. And we're looking at our society. So.
Well, but one of the reasons I think this, you may remember in 1967, the Supreme Court considered a case that where Virginia banned interracial marriage. At the time, there were 16 states left banning interracial marriage. Now there are fewer states standing that do not recognize same-sex marriage. So it's like the time has come.
All right, folks, we're really out of time, so anyway, hope you've given some things to think about. Certainly, you're all going to be watching the news like me, I hope, to watch how this develops. We'll see you next time on Financial Insider Weekly.